Once upon a time, there was a loving couple. But unfortunately, the fairy tale has ended, and Dan and Dana are fighting their way toward divorce. The next morning, Dana leaves with young Daniel to her parents, 100 miles away, and doesn't intend to come back. Dan is approaching his family law attorney and asks him stressfully, "Bring my son back." The attorney, who wishes to serve in his client's best interests, directs a talented and skilled associate lawyer in the office to search all electronic legal databases available for relevant judicial resolutions that could assist their client. After 3 intensive hours searching the electronic legal databases, the associate lawyer looks like this. Only 2 partly relevant cases were found, and this is not enough. It seems that the most basic step of finding a leading case to the issue in question is in many cases actually far more difficult to attain. But why is that? One of the primary reasons for such a difficulty is the selective publication of family courts rulings in the Israeli legal system, which creates a body of secret law. Family courts hearings are held behind closed doors, and therefore it is prohibited to publish their rulings, unless the judge explicitly permits it in writing while omitting the names of the parties. For information to be meaningful and useful, it must be available at the time it is needed. But Israeli family law attorneys are forced to act on a regular basis in a challenging information environment that is lacking published court rulings. Their legal work tools are under the veil of confidentiality. Electronic legal databases hold only a very small percentage of the family court's decisions given constantly on a daily basis. It seems that there is more legal shade than light. So how do Israeli family law attorneys make a living? And as we know, they make their living very well. Well, the answer lies in something that we are more familiar with when we talk about penicillin, X-rays, or the Viagra pill. All are examples of serendipity, the knack of making fortunate discoveries unexpectedly by accident or coincidence, as Reitz has described it. The coinage of the term serendipity is attributed to Sir Horace Walpole, who back in the 18th century wrote a letter about an ancient fairy tale called The Three Princes of Serendip, in which he described that, as their highnesses traveled, they were always making discoveries, by accidents and sagacity, of things which they were not in quest of. Our research provided for the first time a detailed examination of serendipity in information-seeking behavior of Israeli family law attorneys. Through Erdelez's information encountering model, namely through their memorable experiences of chance and unexpected encounters with useful family court rulings, quantitative data from 135 Israeli family law attorneys were collected using a web-based structured questionnaire. Guess what? Such family law attorneys were found to be super encounterers. They encountered family court rulings on a regular basis. They considered these chance information encounters as an important and beneficial element in their professional information-seeking behavior. In the challenging information arena of family law, discovering court rulings by chance is all the more important and powerful to the legal practice. Such encounters may expose lawyers to meaningful and valuable information, which would unlikely be found purposefully, due to the information's limited and selective publication and the lawyer's lack of awareness about its existence. Such serendipitous encounters with out-of-sight court rulings build up lawyers' ability of keeping up with augmented body of current law that better serves their clients. Findings show that Israeli family law attorneys encounter family court rulings through various information sources, by spending time on surfing the web, paying attention to judicial resolutions being added to the electronic legal databases, scanning case law updates publications and recent legal journals and literature, going over a private collection of previous court rulings, and even examining references made by the counsel for the adverse party. Yes, the adverse party's references may be valuable in other cases being handled. Furthermore, informal sources of information such as interacting with internal and external colleague lawyers and attending professional events as conferences and seminars were also found as conducive of serendipitous encounters with family court rulings. The study also identified for the first time 4 key professional problems and concerns that stand in the background of such unexpected and valuable encounters, and represent the relevancy of chance encounters to the full scope of legal services provided by Israeli family law attorneys, namely closed, open, and potential cases, as well as assistance to colleague lawyers. The value of these unexpected encounters with family court rulings was also explored and found to be manifested through 7 different key professional contributions. Most significant ones were support for an argument claimed or considered to be claimed on behalf of a client, followed by contradiction of an argument claimed by the adverse party, and manifestation of an additional or different thinking course or reasoning. Seems these lawyers are on the right track for winning the litigation. The bottom line? Chance encountering of such legal information could have a big practical impact on family law attorneys' legal practice in favor of their clients' interests. The study also has implications for the improvement of legal research and information-seeking instruction, of nonlinear information acquisition,